All right, y'all. Hey. Happy Friday. It seems like I'm losing connection already, and I haven't even done anything. Happy Friday. As you guys pop in, say hello. Give me a thumbs up if you guys can hear me okay. Give me a thumbs up if you guys can hear me okay. Alright, Joe coming on in. Alright, hey, cool. Alright, cool. So I know this is literally like the middle of the day, and this is probably not the best time to go live, but this is the only time that I have to go live. So here we are, guys. I tried to go live, and every time I keep trying to go live, it keeps giving me an error message, probably because I don't know, I guess some of my other lives or whatever. So y'all just keep making sure y'all can tune in. So this video is going to be, first of all, let me give my disclaimer. This video, the contents, anything contained in it is for educational purposes only. I am not an attorney and I do not practice law. So now we got that out the way. This video is probably going to be very triggering. It's probably going to be very triggering for a lot of people, and that is okay. I'm going to do it anyway, right? But I want you guys to first understand that in this video, as I go through it, this is going to be multiple parts because it's too much for me to break down in one. So I'm going to break it down. Today we're going to do part 1. Then we're going to do maybe 3 parts, part 2, and then the last part, if I need to do it in 3, will be an actual court case that was actually filed, and I'm gonna show you guys the response from that. So I told you the good, the bad, and the ugly. I'm always gonna come and give it to you guys. So that's that. Now in this video, hear me well before y'all start getting emotionally triggered. I am not saying that this process is right or wrong. That is not the purpose of this video. I am here to show you guys where you may come into litigation issues if you decide to go and use this particular process. So 1, I'm going to show you the process. 2, I'm going to show you some litigation issues you might come in. And then I'm going to send you on your way, and I'm going to challenge you to go and seek and find and do whatever it is you need to do. So again, hey Paul. So again, listen, turn the emotions off. It is what it is. So let's jump right into it. So you guys know that negotiable instruments and all of those things are not my lane. It's not what I like to do per se. And here is why. Let me give you some context. I don't personally like the whole negotiable instruments and things like that because I don't like to operate in anything that was not created for me. I don't like to play the Monopoly. I don't like to play the cupcakes in La La Land. I don't like to have to be the agent acting for the principal. I don't like to be a fiction and a character because I'm not a fiction and a character. So for me, that is just not the way that I personally have decided that this is the way that I want to relieve myself of debt obligations or gain financial freedom. Now, am I saying that it is wrong? No, but I'm just saying for me, that is not the way that I choose to go. And I've seen so many issues and what happens when you do that. And I think that in this commercial law space, there is a lot of information that's going forward with no contact, no understanding. I believe that there's all of these webinars, master classes, and weekend things and all these things. But at the end of it, I myself have sat in them. And at the end of it, I don't have any more understanding. And the understanding that I thought when I initially did this turned out to be that it wasn't the case. So I want you guys to understand and fact check everything I'm saying because for 1, I'm not an attorney. I already told you that. For 2, I do not have all of the answers. I don't know everything. I don't pretend to. However, a lot of these processes are on the surface just retarded. It just doesn't make sense. Some of the things are just not for us. And what's happening is these processes are being out, they're being taught, they're being shared all over by whatever people, for whatever reason, whether people believe that the information that they're giving is correct, whether they're getting the information from other people and then just recycling it and regurgitating it for money grabs with no substance or understanding. All of these things have truth. So when you read things and you see negotiable instruments and you see those things, it's not made up. So yes, negotiable instruments are actually a thing. They thrive, right? The UCC is actually a thing. The Bill of Exchange is a thing. So you have to be mindful that just because somebody is presenting something to you doesn't mean that it's the thing for you or that it's applicable to us in our everyday lives and who we are and how we came to exist and be. So that's what I want to say with that. And anything can sound good when you don't know what you're talking about or when you don't have an understanding. So anybody can make something sound good and can pump you up to believe that these things are going to work and it makes sense because they get online or they get into classes or whatever, and then they read it verbatim, give you context and make you think that it makes sense. But if you dig beyond the surface, these things don't make sense. So that's just my spill. That's my context. So for me, I always go behind the scenes of things. I told you, I believe in foundation. I believe in going back and researching and figuring out, well, when did these things come into play? Why did they come into play? They didn't just jump out the sky. So if a process was this way and then now this process is now implemented, what happened? You get what I'm saying? Why did it happen? Did it affect us as being men and women as a result of it happening? So just because you read something, if all you got is this little Google answer and you don't have any context behind it, it's going to mess you up. So this video is another video where I'm just here to make you think, and whatever conclusion you come up to and then whatever you decide is on you. So let's jump into it. And I got my piece of paper and my notes to make sure that I stay on point. So let's talk about these negotiable instruments that you people want to keep dragging me into. I told you I didn't want to do it, so I started looking at it. I started seeing where people were like, oh, UCC 3-603 says if you tender a payment in a negotiable instrument that the amount is discharged and you can just do this, and you can do that. And I'm like, okay, cool. Let me dive a little deeper into it, and here we are. So I'm just going to share with you some of the basis of what I came up with. All right, so let's jump into a negotiable instrument, right? So the UCC, which I hope you guys can see my screen, but can you guys see my screen? I know you guys might have to shift your phone, and that's going to be okay, but can you guys see my screen? Thumbs up if you can see my screen. Thumbs up if you can see my screen. I want to make sure you guys can see it. Hopefully you can see it. All right, so the UCC defines a negotiable instrument as an unconditioned writing that promises or orders the payment of a fixed amount of money. So, okay, cool. What does that really mean? Okay, the UCC defines a negotiable instrument, but then I had to ask myself, well, what the heck is the UCC? Where did the UCC come from? What does the UCC govern? And I'm just giving y'all just surface stuff. Now, I didn't did my research, but I'm not going to give all that to y'all. This Pre-Game Friday, but I ain't going to give you all of that. All right, so first thing is the negotiable instruments that you guys are using, so to speak, it comes under the UCC. So if you go to the UCC, so let's run down to the UCC real quick. The UCC, on the first page of Google, and I don't even really like Google or trust Google too much these days, but on Google, Google says the Uniform Commercial Code, the UCC, is a comprehensive set of laws governing all commercial transactions in the United States. The Uniform Commercial Code is a comprehensive set of laws governing all commercial transactions. So now you take it a step further and say, okay, the negotiable instruments came from the UCC. The UCC governs commercial transactions. So now you go to commercial transactions, right? Now here, let me stop here with the commercial with Google. You have to be careful with Google now because Google will lead you astray. So you have to start finding credible sources like the Black Law Dictionary in some aspects, right? The dictionary, different things, because the definition that you decide to use or what you decide to go with is going to determine how successful you're going to be in litigating your case, or determining if something actually applies to you or if it doesn't, right? So commercial transactions, I don't even deal with all of the rescission and all of that stuff. Now, I actually went through the actual thing. So I'm going to try to find one that is better. Okay, Collins Dictionary. I kind of like Collins a little bit. So let's do Collins. LexisNexis. Law Cornell. Be careful with Law Cornell too. I'm froze. Am I frozen? Thumbs up if I'm back. Thumbs up if I'm back. Am I back? Am I back? Am I back? Thumbs up somebody if I'm good. Am I froze? I think I'm delayed, but I don't think I'm froze. I think I'm on delay. Okay, cool. All right. So I don't like Law Cornell too much because Law Cornell play a lot of games with their definitions. So you kind of want to go to like a regular dictionary, old black law. When you're trying to define stuff, I don't know that I would really trust Google or Law Cornell. For me, that's just my opinion. And you can see why, because it starts talking about rescission, trust, estates, and all those things. And those things will confuse you. The more words something is, the more confusing it is. So, nevertheless, on Collins Dictionary, it says, what is that? Okay. Commercial means involving or relating to buying or selling the transaction. So commercial in itself means buying or selling. But then when you add transaction, because you got commercial, which is one word, which commerce is the act of buying and selling, right? But then the transaction, when you put it together, means it's a piece of business. So whenever you're thinking about commercial transaction, it's typically for businesses, people that are operating in trade, commerce, interstate intercourse, traffic between the states, interstate commerce, right? So in this aspect, now my question become, when I was doing this, and my question to you is, if you are not operating and you purchased a car, if it wasn't for business and it was for personal and household, then how could it have been a commercial transaction? Hear me well. If you purchase a vehicle and you check the box, you'll say that it's for personal household goods. It's not for business. You do not. So when you are operating in business, the reason why you are buying and trading and all of those things is to make a profit. That's what business is for. So in layman's terms, anything in a commercial transaction is you're doing it to gain a profit. You're doing it for business. You're not doing it to sustain your own personal stuff and for your household, or, you're not buying it to maintain your household for your family. Thumbs up if that makes sense. So my thing is this. If these negotiable instruments is governed under commercial transactions, is the UCC. If you yourself are not operating in business, how are you using negotiable instruments? How are you tendering negotiable instruments? Are you actually allowed to tender negotiable instruments? Are your negotiable instruments valid? Should you be even using negotiable instruments if your purchase was not a business transaction, or you did not buy the good for a business transaction? The same thing if you have a mortgage. If you have a mortgage, your mortgage is your primary residence typically. If you are buying it for your personal self and for your family, you're not buying it to operate and gain profit off of it as a business. So if you are in a mortgage foreclosure, if you are foregoing mortgage, how are you tendering a negotiable instrument if the transaction in itself is not commercial, but it is for personal, family, and household goods? That's all I'm going to say about that. I'm just here to make you think, and that's going to be that. So then you'll have people that'll say, okay, well, let me go here. Matter of fact, let me pull this up. So we define commercial. So then you'll have people that will say, well, so let's define a consumer transaction, which I think you guys should know what that is, but I don't want to leave nothing by chance for y'all. So a consumer transaction is where one party purchases goods or service for personal, family, or household. So there is a distinct difference from a consumer transaction or a commercial transaction. So you have a consumer transaction, right, which is for personal, family, and household goods. And then you have a commercial transaction that is for business. So my question is, if negotiable instruments are for business, what are you supposed to be using, or what are we supposed to be using when we are operating and our transaction is the result of we're purchasing for personal, family, household, and goods? I guarantee you, if you look that up and do the comparison, you'll find that there is a distinct difference. In consumer transactions, you cannot use negotiable instruments because negotiable instruments come under the process and they are governed under commercial transactions. A thing similar is not exact. So again, if your contract was the results of a consumer and not a commercial, then you got to know what process you're using. So you have to determine if it was consumer or commercial. And if it was not commercial, then you got to ask yourself, why the hell are you using negotiable instruments and tender payments? I'm just talking about what I'm talking about. And I am not saying it's right or wrong. I'm just telling you where you guys are going. I'm leading you guys into where you're going to have issues at with litigation. All right. So now you'll have people that say, well, that ain't right because we are the agent / principal. I'm the, what do they say? I am the agent for my principal, the principal for my agent, whatever way it go. But I am the agent for the principal and all of those different things, right? So then that means an agent principal relationship has to exist, because the idea is, and again, this ain't my lane, and I ain't saying it's right or wrong, but I'm just saying. So it's a principal agent. So a principal agent relationship is created when the agent is given authority to act for the principal. All right, now listen to this. A principal agent relationship is created when the agent is given authority to act for the principal. So a lot of the times, who is the agent and who is the principal? I want y'all to answer this because I don't really know. I think that I have my own idea and my own understanding, but when I read some of your documents, doing consultations and doc reviews, a lot of y'all are mixing it up. So is your straw man the principal or is your straw man the agent? Are you as the living and flesh blood man the principal, and then you are the principal and then your fiction person is the agent? So let me hear from y'all. The thing is, they was treated as if it was a trade all over, but here's the old in due course for COVID-19 say, but that wasn't my question. I agree with that to a point. So again, if you have a principal-agent relationship, right, and you are operating, this agent-principal relationship is the results of another process. Now, if you're using that process, you should know where agent-principal relations derive from. I don't even think that I found it on Google. I found it, but I found it in an old book. Hold on. Let's see what Google said. Because sometimes you guys don't know how to break things down. Where did agents principal, I should have said principal. I said it backwards. Agent principal relationships come from. I should have put originated. So these are the questions, because I'm not going to go dig deep if it don't pull up. But these are the questions that you need to ask yourself. So the agent-principal relationship originated, it says, emerged in the 1970s from the combined disciplines of economics and institutional theory. What is the creation? It says when an agent is given authority. I found that I'm not going to say it on here because then people will go and try to regurgitate it and do all that, and I'm just not going to do that. However, nevertheless, so let's just say that I have heard what people say the agent-principal relationship is related to surety and subrogation, right? It's surety and subrogation. So whatever the surety and subrogation process is, wherever this agent principal relationship originated, that is the process that you should be using. So what happens is you start mixing processes all together, and then because you don't know where the processes came from, or really why you're doing stuff, you don't even realize that you're mixing a whole bunch of processes together. And so then when you go to draft your notices or you file your lawsuits, you're not getting any results, and the courts are just going to play in your face because the lawsuits are all over the place. They don't make sense, and you're just mixing this piece, this piece, this piece. Oh, this person over here said that, so I'm going to put this here, I'm going to put this here. So I'm not saying that the agent-principal relationship is not a thing. I'm not saying that it cannot work in this process. What I am saying is that if this is the process that you're going to use, you should at least know where this agent-principal relationship came from. And it should not be the only understanding that you have, and the only context that you understand is because you got it on a master class or you got it in a webinar or anything. I don't care if you even got it from me. You should go back and make sure that you have your own thorough understanding and your own context, because when you have to go in front of the court, and I know the whole idea is we're not supposed to go to court and we're not going to have to see the courtroom, but because people are now doing these processes and they know they can't stand 10 toes down, now I'm being the bearer of bad news again. 9 times out of 10, you're going to have to go in the courthouse. There's not a whole lot of you ain't got to go in the courthouse. That was cool before y'all start flooding the courthouses with all these bullshit motions and not knowing what you're doing. So the thing is, when you do these things out of turn and out of season and without understanding, you just make it hard for us to get out of this matrix. Because then they say, okay, this is the information that's out, and then they all go have a meeting, and then they all huddle together, and then they just change it and figure out ways where they can catch you up, where you can't come, and then somebody else that's educated now has to go back and try to break it down. But then what happens is the people that get educated, they're not going to come back to Instagram University, because y'all won't take the time to do it and do it right. You just do it, you hear it, and somebody tell you one thing, and you won't go open a book, you won't go look, you won't try to get context, you'll do it, and it just sets us back hundreds of goddamn years. So I'm telling you, I told y'all first that when we were doing the whole credit repair and that whole movement, I said the only way we're going to get results now was going to court. Y'all didn't like it. Okay, well, now I'm telling you. Now, at first, I was one of the ones that was saying, listen, if you do what you're supposed to do behind the scenes, you ain't going to have to go to court. But now y'all want to create templates, and now y'all want to regurgitate the information. So now they're going to test you and make you come into court, because they want to see if you are the person that actually can stand on your square. They want to see if you the person that really know what you're talking about. They want to see, or you just a person that just took a master class or just took an Instagram class or just saw me on Instagram or saw somebody on Instagram and just turned and wrote it down. So they got to weed through. So guess what? 9 times out of 10, you're going to court. It just is what it is. So make sure, again, if you're going to use this agent-principal relationship, make sure that you are using a process that is geared for agent-principal relationships. So again, in this process, and I don't know about subrogation, because subrogation gives me a headache. It's a lot of things I can teach myself and get and understand. Subrogation is not one of them. I don't care how much I look at it. It doesn't make sense to me. And I guess because, again, I just cannot operate in cupcakes and la la land. It's black and white with me. What makes sense, and what doesn't. It's almost the equivalent of people talking about, like I was on Instagram, sidebar, I was on Instagram, and there was this thing, and I don't know how serious it was, because I think some people be trolling, but this person didn't identify as a man or a woman. They identify as something else that like just doesn't exist. So for me, it's okay if people want to exist in calling themselves whatever they want to call themselves and identify whatever they want to identify. And I hate using this example, but this is one of the trending topics that I feel like it's a context that we all can relate in. So this is not an attack against anybody or what their belief is, because I'm a firm believer of believe in whatever you want to believe in, do whatever you want. But when it comes to me, there is only 2 sexes, man and woman. That's it. Now, if you decide you want to call yourself a cat or a goat or non-binary or whatever it is, that is your choice. However, for me, I just don't want to play in that game. So that's how I feel when it comes to, oh, you a straw man. I am not a damn straw man. I'm 165 pounds living. So I'm not a fiction. I'm real. You can touch me. You can feel me. I can talk. I have mental capacity. You know what I mean? So for me, it just doesn't make sense to me. It doesn't make sense. But nevertheless, getting back to my point, if I get all amped up and sidetracked, the agent principal relationship, from my understanding, goes with the process of subrogation, or whatever it is, subrogation and surety. So subrogation and surety has its own process to do things. So if you are doing subrogation and surety, then the process that you should follow should be related to that. You should not be using this law, that law, that law, this law, that law, and putting it all into one, because when it comes down to litigation, you're going to have a major, major problem, okay? I've seen I was actually just working on a case where somebody said do subrogation, and they put all that stuff on the court record, and the court literally ignored it. Like, it didn't even matter. The negotiable instrument, they ignored the whole process of it, and the person couldn't even make it make sense to be able to even respond. So you have to understand that even if these processes are right, the attorney is going to have an opposition. They're going to file a motion to respond, because that's what happened when you go to court. So again, if all you have is this little textbook understanding or this little Google understanding, is not going to go far. So again, that's that, right? So that's the agent principal relationship. All right. So I showed y'all that you got the consumer transaction, and then you have the commercial transaction. So for the people that say, well, it's all commerce, is it really all commerce? It's all commerce because you accept it. And yes, it's all commerce, but there's two different sides of commerce. There's the consumer side of commerce, and then there's the commercial side of commerce. And you have to understand which one you want. And if you cannot bring that together and know distinctly the difference, then I'm just going to tell you respectfully, you should not be tendering negotiable instruments. All right. So in the litigation part, this is where a lot of you guys are going to, well, you're probably not going to be able to see my board, is going to have issues, right? So when you are litigating, you have to decide a strategy. You have to decide which way you're going to go. When you see attorneys and you see skilled attorneys and stuff, and they're in court, they very rarely have I ever seen where they change their strategy. Because for one, before they even go into court, they look at the case, they strategize and figure out, okay, this might be where I have an issue at. This law might not work here. This might be a contradiction. So they decide before they even draft a complaint, comes to you guys, try to garnish you or respond, how they want to respond. So the first thing you have to do is decide what law you are going to use. If you're bringing a lawsuit, if you're responding. So let's talk about if you're bringing a lawsuit, and then I'll switch to if you're responding. So if you're bringing a lawsuit, right, and you say you're using negotiable instruments. So you got this lawsuit, but you have to decide, are you using consumer law, commercial law, y'all, excuse my handwriting, or God's law, constitutional law, I don't think common law, I guess. I can't think of nothing else. I feel like I missed one. Natural law, law of nature. I don't know. I think law of nature and God law can all kind of tie into the same. All right. I know my handwriting stuff, but nevertheless. So you have to decide, am I going to bring my claim? So somebody infringed on your rights, right? They're trying to take your car. You feel like you shouldn't have to pay for your car. Which I think is crazy. But nevertheless, so now you got this lawsuit. So now you're talking about you want to use negotiable instruments. You cannot use consumer law, because consumer law is only governs personal and household. So TILA, the FCRA, the FDCPA does not go with commercial law, because the laws for consumer law governs personal household. So if you're going to use consumer law, then technically you wouldn't use negotiable instrument. So if you put consumer law in here, but then you tender a negotiable instrument or you use negotiable instrument, you're going to confuse the court, because the court is not going to know what law you're bringing this claim under. And so when you're asking a judge to litigate a claim, and you're asking the judge, because when you go to court, right, and you type your complaint, you're supposed to be the one that's saying how they violated, what laws did they violate as it relates to you, and what is the nature of the action, like what law are you bringing it under, right? And so if you say, okay, well, I am a blood flesh man, and I am born of the earth, and such and such, but then you tender negotiable instrument, how are they supposed to determine what laws or rules apply to your case? Because you didn't put consumer here, and you didn't put, but then you didn't tender commercial. And so hear me well. When it comes to at law looks at the form of things. So it doesn't matter that you say, I'm a blood man or woman, and I got this free, unlimited credit plan, an extension of credit under the Truth in Lending Act. I got an open credit plan, right? Which is not true, but in the instance that people said, but that will be a video for another day. So I got this open end credit plan, and I'm supposed to have this stuff, and I'm the creditor, and I'm all of this. But how can you be the creditor over here, but then when you use commercial, you're considered a merchant? So in consumer law, it's creditor, so you speak for Tila. Now, I'm telling you that's not true. I'm just giving y'all an example. So over here, you'll say, under consumer, you in some instances, y'all say, I'm a creditor, I'm a man, I'm / a woman. So this is what you're identifying on the consumer side. I'm a creditor, I'm a man, I'm a woman. But then you turn around and you tender a negotiable instrument, which I didn't tell you guys, but before it was called the Uniform Commercial Code, it was the negotiable instrument law, and before that it was called the law of merchant. And if you look at law of merchant, that's literally merchants, it's business. So my thing is, so hear me well. So if you're saying that you're quoting TILA law, you're quoting consumer law, which protects man and woman, but then you using stuff talk about your creditor. Now, let's say for all intents and purposes, again, that's right. Over here, you're identifying as a creditor, man or a woman, because you're using consumer law, but then you're tendering a negotiable instrument that governs merchants that identify as a merchant. So you're confusing the court because they don't know what the hell you identifying as. Which one are you? Because you can't be all, and I know y'all like to think that y'all are, you can't be all things at all times at once. So you got to pick a side and decide which one you are. But in no transaction are you going to be the creditor, the man, the woman, and the merchant. Right? You're absolutely correct. They're all right, but they all operate in different places. So now hear me. Now you can say that you are the creditor because you extended credit and all of that, and they converted your assets and all of that. Because I do agree with that. I do believe in. Now I won't get too much in that because again, then y'all just go regurgitate my information. But if you are going to do that, the negotiable instrument don't have to come into play for that. So if I'm going to say, I gave you something, I gave you an asset, I gave you a security instrument, you stole my identity, you did all of that, why the hell am I turn around and tender you a negotiable instrument? Why would I do that? What literally would be the point of that? Because as you took something from me, but I'm going to turn around and pay you for the very thing you took from me? Because the idea is when you're tendering or using a negotiable instrument, the reason you're doing that, most of you guys will say, is to discharge a debt. So if you're trying to discharge the debt, then that means that at some point, if you're trying to discharge the debt, rid the debt, that you agree that at some point you accumulated the debt. Now, I'm not getting to if it's already paid, because if it's already paid, then why are you trying to repay it? So that whole, well, all our debts is already paid, then why the fuck are you tendering a negotiable instrument? Why would you, that's the equivalent of you got a pair of shoes, you already bought the shoes, but then you're going to go and take the shoes back and pay the person 2 times for a pair of shoes you already had. It doesn't make sense. The math ain't math and the common sense ain't common. That just doesn't make sense. So again, which one are you going to be? You have to decide, because if you take something from me, I'm not coming back to pay you for what you took. What my claim and my argument is going to be is fraud, is misrepresentation, and you did some fraudulent and foul stuff to me, and I don't appreciate that. Now we got to come back and we got to fix this and we got to correct this, and now you're going to have to give me some remedy for what you did to me. But what you did to me is not going to equate to me giving you a negotiable instrument. Exactly. I come to claim. So if you claiming what's rightfully yours because you got all this opening credit, because you the creditor, because you dropped out the sky with your bad self and everything in the world is free and all debts is the obligation, why you sitting on the negotiation? And that whole we got to do the debt ceiling and all of that, that has nothing to do with merchant law. I'm letting you know right now. That has literally nothing to do with merchant law. And if it does, I don't know, and neither do y'all. The ones that I'm talking to are the ones that's in these master classes. We don't have the understanding at this point right now to even understand it. So why are you saying things that you don't even know that's true? There's no proof of it other than somebody teaching it to you, or not even teaching it, them telling it to you. So you gotta go and fact check everybody. And it ain't that you gotta go fact check them and find out they're wrong and come back and blast them, but just kindly just go and just kind of say, you know what? Let me go see if this makes sense for myself. Let me go read this and see if it come up. But what I'm telling you is, in your lawsuit, this is why you're losing. Because you can't be the creditor, man, the woman, and the commercial and the merchant at the same time. And in this instance, you're never a merchant because you're not the one that's actually purchasing the good that is subject to the transaction. Now, I know we like to think, and again, I don't disagree that when we sign the contracts, not the promissory notes, because we don't use promissory notes, we sign contracts. So when you sign the contract, do they probably negate, convert it, negotiate it, do different things, change it up, convert it? Listen, I'm just talking about what I'm talking about. However, that is a different idea other than if you're going to go purchase a vehicle, if you are purchasing a home under a mortgage, the note or the contract or the asset does not make you the merchant. So yes, maybe you can be the creditor, but it will never make you the merchant. Because you're not even selling securities or anything. And that's all I'm going to say about that. If you caught it, you caught it. If you didn't, watch it again, catch it again, and figure it out. Give me thumbs up, y'all, if that makes sense. So this is why you're losing, because the court's job, the judge's job is to look at your complaint and then go to the law, and based on the law, decide if your claims are sufficient, if you have alleged a prima facie complaint, meaning it makes sense, it's credible, it's based on some type of law, and then they can look and say, you know what, based on the Truth in Lending Act, this person was violated. Okay, we see that. Okay, based on, the FCRA, we see where the Consumer Reporting Agency's violated that. Okay, based on, so now you give them something to work with. But when they don't even know what law you bring in, what nature you're bringing your claim under, how the hell are they going to litigate and find out if you was injured or not? Because you think they can go through 20 different laws to figure out what the hell one you talking about and which one you talking about? No, sir, no, ma'am. That's not how that works. So you're not even giving them anything to work with. So all the time, now these courts are rigged, and let me let you know. They definitely, they do what they do. But a lot of these times, you're not even giving these people something to work with if they wanted to work with us. Because you're not even bringing it in correctly. You're just putting stuff there. And that is not how that works. So that is the number one main reason why most of us are not winning, because we are all things at all times. And the court has no way to decipher what it is. That's why they say you failed to state a claim, because they don't even know what the hell way to go. And they're not get ready to do that. Now, I want to pause on the sidebar. Now, I will say, I can understand in some cases why you guys may be confused, because even myself, I've done it. They're not made stuff up, but because what they do is they bundle up a whole bunch of things and compile it for them to be able to advance the fraud that they do. And so when you can see, okay, they're using consumer here, but then they're doing this, you can identify. So naturally, when you see that, you want to respond to each piece of that. And that's not, you can't do that. And I'm telling you, not from what I Googled, but what I know. So I'll give you an example of what that looks like before I move on to my next point. If you have a retail installment sales contract, and I'm not going to wait for you guys to pull it out, but hear me and hear me well. If you have a retail installment sales contract, it'll say retail installment sales contract or retail installment sales agreement or something at the top. Somewhere in that contract, right, it will have a big box, and it's usually to the right. It's usually in a box to the right, and it'll say consumer transaction. This transaction is a consumer transaction, and whoever is the holder of this contract or something is subject to all the claims and defenses that can arise or something. If you've seen it, if you go back and look, you'll see. I'm probably not saying, and I don't think I got a contract right here. I'm probably not saying it exact. Well, I know I'm not saying it exact, but it's similar. So I'm going to tell you again, it's in the right-hand side usually. It's like a box in this where it talks about like if you want insurance and how the insurance is supposed to be covered. And it might be where the cooling period is, but it's a box. And it says consumer transaction. And it says that is, again, it says something like this is a consumer transaction, and whoever is the holder of due course, or whoever is the holder of this note, because then they call it a note. So they call it a consumer contract, but then they call it a note, if you get it. And then they'll say that holder of the note is subject to all the defenses in the claim that the person, that the borrower can bring or whatever, right? So here's the thing. So in our mind, we're like, well, you're calling it a consumer contract, or you're saying whoever is in possession of this consumer. So now I know that it's consumer, but then I'm looking at some of these words, and I'm looking at like promissory note, and I'm like, but promissory note and consumer law don't really go together. So now when I am drafting up a complaint, I'm drafting up all of and responding to all of the issues that they put. And then with that, what happens with that is it becomes a big pile of mess. So I'm telling you, and I've even seen this with lawyers and attorneys, and I've read their cases, even though you can get somebody or you can get them on everything, sometimes you may just have to settle with the one thing so that you can diligently stick to that one thing and diligently use that one thing to get the remedy. That's why I actually came up, if you want to be truthful, with the one law, one strategy. Because putting a bunch of different laws and labeling all of the things that they did wrong, because they do so much shit that's wrong, it was so overwhelming. And it was almost impossible because you're dealing with the odds already stacked up against you. So when you're trying to prove that they did this and they arguing about this, and it just becomes an emotional mess. So that's why I say one law, one strategy, because all you need to do is show that they violated one thing fraudulently and everything else go to hell. And then your damages and your remedy is going to come from the damages. So you don't need 20 different laws that they violate in order for you to get remedy for your injury or your damages. Does that make sense? It's because they treat those mortgage notes and negotiable instruments, they stamp as pay. Exactly. But here's my thing, and I'm glad you said this, and I wasn't going to say this, but I'm going to say this. And then what we'll say is, well, we gave them a negotiable instrument. No, we never gave them a negotiable instrument. Now, what they do with it after we give it to them, that's totally on them. But it never changes the intent of what you did. So when I signed this contract, I signed this contract to evidence the debt. My contract, when I signed this contract, I signed the contract under contract law. Hear me and hear me well. That's what I forgot here, y'all. How the hell I forget contract law? Thank you, love. Remember I said I was forgetting something. How in the hell I forget contract law? Thank you so much for that reminder. So, yes. So, when I signed that contract, I signed that contract based off of this is just a legal binding agreement between whatever parties. So if I signed a car contract, I signed that car contract. I don't care what you call it. I just signed a contract just to show, hey, if something happened or whatever, I agree that I'm going to pay you. And if I don't, these are the consequences and what's going to happen. And I agree to that, right? So when I bring my claim, I'm going to bring my claim under contract law. So again, I'm so glad you reminded me of that. So I'm not going to go to UCC because my whole idea was under contract law. So why would I ever use commercial law when commercial law had nothing to do with the reason why I'm coming back for what you did to me? But nevertheless, so that is why, that was a good point, thank you. So that is why the court is confused, because now you got too many things and you got too many statements and nothing is making sense, right? So then if you're going to say, okay, well, I am the consumer, it's not enough for you to just say that I'm a consumer. Now, yes, your statement stand as truth unless they rebut it. But if you really want to win these claims, he who makes the claim has the burden of proof. I say this every video I do. I say this in every consultation, and I will hope at one point or another somebody understands how detrimental and serious that is. Anything that you say out your mouth, anything that you put on that piece of paper, you have the burden of proof. So you can say that you are a consumer all day long, but what happens if the attorney come back and be like, you're not a consumer? Do you know how to prove that you are a consumer? And not even prove, but do you said it, so actually you do have to prove. Do you have any evidence that can show that you are a consumer? Do you know in this transaction why you are a consumer? So you can do things like, okay, I am a consumer and I purchased this vehicle, and when I signed this contract, I signed it out and I did it for personal household. So in that instance, that makes me a man that is a consumer, or I am a woman that acts as a consumer. That's how I word it. Because I'm actually not a consumer, I'm a woman. So I am a woman who sometimes acts like a consumer because I consume things. Does that make sense? And so at that point, it's not just enough to say, well, I'm a consumer pursuant to so-and-so, so-and-so, because if somebody rebuts that, what do you have in place to rebut that presumption? So you have to do that. So if you're going to say that I'm the agent, that there's an agent-principal relationship, you should have an Exhibit A that shows why their agent-principal relationship exists. And hear me well. Just because you quote the law to say that this is an agent-principal relationship does not mean that you are actually in an agent-principal relationship with yourself. Hear me and hear me well. Just because you say that you are in an agent-principal, people lie every day. So you want somebody to believe that you're in an agent-principal relationship, but if somebody comes to me and we in court, or they talking to me and they say they're agent-principal, what the hell is that? You have to show me some proof that you're in an agent-principal relationship. And you reading the law to me and say, well, agent-principal relationship because you got it off Google, great. You explain to me what an agent-principal relationship is. Thank you so much for the definition. But show me how you are in an agent-principal relationship. And most of you guys can't do that. And because you can't do that, or you don't know that, I know damn well you're not providing the evidence enough to do that. And so what happens is your claim is going to be denied because all they're going to say is you are reciting and you're saying conclusory statements. Because you're just making statements. Statements are not evidence. Statement is not proof. So you're saying that I am the principal for the agent, or agent for the principal, whatever the hell y'all say. The fact that you said that doesn't make it true. When you just put the statement of what it is, all you did was define it. But defining it doesn't make it true. Thumbs up if that makes sense. So again, if you're going to use that, you have to attach to your lawsuit when you make the statement, there should be an exhibit to show that. And now your affidavit, and again, it's just going to hurt a lot of feelings, but it is what it is, and I'm just talking about what I'm talking about. Just because you type up this agent principal statement and this security agreement and all these different things that I've seen. Listen, I've actually done it before too, but I didn't use it because it just, at the end of the day, I was like, this shit don't make sense to me. And it, again, I'm not saying that it's right or wrong, but it did not make sense to me. So I just negated it. So I know what I'm talking about when I see these forms. So if the form says, and this is a form that you typed up because you done got it off a scribe, you done got it again from somebody else, this is template, it doesn't mean it's true just because you said that you're the agent and the principal. So your document alone is your own self-authenticated document doesn't make it true. Because all you did with affidavit is just your own self-authenticated document. You cannot self-authenticate your own documents. That's the whole purpose of a notary. It's for somebody else to attest to it. So your own stuff that you come up in your mind, your facts, your feelings are not facts. Your truth is not always the truth. And the things that you think is true is not always what other people think is true. And so when you're going into the courtroom, you're not just dealing with your truth. You're dealing with people clearly who have different ideas than you, which is why we are in dispute, which is why there is controversy, which is why we go to court. Because if there was no dispute or controversy, we would not be in court. So somebody is thinking I'm a fiction, and I'm here to let you know I'm not no damn fiction. That's the discrepancy. That's the dispute. That's the controversy. Show me where I'm a fiction. I've never participated in this, and if I did it unknowingly, and I don't want no parts of it. So those are how you have to do those things. Does that make sense? I gotta calm down, y'all. It took me a little while to get it out myself. Let them see and agree. Oh, they trust it. Yeah, exactly. Agreed. So does that make sense? So again, when you go to court, just because you put your own self-authenticated documents, that's not considered evidence. So now you got to know what the rules of evidence is. And if you ever look at that, you'll know a lot of the stuff that you guys are attaching is not evidence. And you'll also quickly learn that the stuff that the attorneys are using to sue you, to take your house and do stuff, is actually not evidence either. It works both ways. Okay? So now if you're going to say an agent-principal relationship exists, you got to throw some history in there. You got to do some case law in there. You got to do some legal analysis. Because the courts don't just get to make up rules that they want to. Like, they have discretion, but the discretion has to be within the law. And here's the thing. There's no set principle of law. Law is whatever law is to you in the space that you're in. So again, if you're using consumer law, then consumer law has its precedents. It has its case law. If you're using commercial transaction under merchant law, guess what? You can go and find case law and precedent under case law. So now you have to go and find cases and say, listen, in this instance, this is the same exact thing. This has already been decided that this is X, Y, and Z. Therefore, please see my document that I put such and such on notice about. So you see how it's similar, but it's not the same thing. And you have to learn that it's not what you do, it's how you do it. It's not what you say, it's how you say it. Does that make sense? And so that's the number one reason. You have to decide which one you're going to be. And you can't be the creditor man, the woman, and the merchant all in one transaction. You just can't be. So then you got commercial law. We already kind of just discussed that. So if you are a business, this is when you should be using commercial law. If you are a business, I am a businessman, you're a businessman or woman. And so if you're going to be using commercial law, then you should only be using laws that governs commercial law. Because if you are operating in commerce, again, the consumer laws are not going to apply. They're not interchangeable. So if you're using commercial law, then your identity, what you need to identify is as a businessman, a businesswoman, or a merchant. And if in that transaction, you're not a businessman, a businesswoman, or a merchant, then you probably will find that you should not be using anything that is commercial in nature. Because that shit don't have nothing to do with you respectfully. It doesn't make sense. Now here's my favorite, because I started to see all y'all want to come over and y'all, now listen. Because I don't like this for y'all. I don't like this for y'all. I don't like this for me. I don't like y'all keep trying to play with God's law. I don't like that. I don't like it. I don't like it. I don't like it. I've seen people where they like, y'all go to church, and y'all know I'm a church girl, old Baptist church girl. And it's y'all go to church. That's a white man religion. The Bible was created by a white man, and all those things may be true. However, you hate it, but then you want to use it when it benefits you. That's not how that works. So if you are going to use God's law, then you have to decide who you are. God's law, as far as I know, and again, I'm not into religion. I'm into relationship. There's a difference. So I'm not big on religion. However, God's law was created for man and woman. In the Bible, it speaks of, which is God's law, right? Or the Quran, or whatever you use, because maybe you don't use the term God. Y'all, please don't make it this whole big thing. Just hear what I'm saying. Whatever Bible, whatever book that you read for your higher being or God or whatever it is, it was created or intended for somebody. It wasn't for everybody. It wasn't for everything. And so when you look at God's law, what does God's law say? Who was God's law intended for? So you got consumer law, which was created for consumers. Now, naturally, consumers are going to be man or woman, technically, right? So that was just another way that they came into play with, just a little history lesson to get you away from God's law. Because the thing similar is not exact. They can't create rules and govern something that they didn't create. The creator, hear me, the creator of a thing owns the thing. The creator of a thing owns the thing. So if you did not create man or woman, then you can't create no law for man or woman, because you ain't create man or woman. It's the same thing for you if you're a parent and you have children. I push my kids out, 7 pounds and 9 pounds. I create the rules for them because I am their creator in the aspect. They came in this world through me. So any rules that and any laws are the rules and the laws that I decide in my house, of course, other than when we teach spiritually and things like that. But you get what I'm saying? I create the rules. You can't, outside of the world, don't create the rules for me and mine. Mine are going to do what I say to do, because why? Because I created them. Does that make sense? And so to get away and do some of the things that they did, they said, okay, let's call these people consumers. So consumers is just nothing. It just took you away from God's law and then did consumer law. And consumer law is protection, but it's also a hindrance depending on how you look at it and what situation you're in. So consumer law did not give y'all rights. Consumer law was supposed to be more of a protection, but it didn't give rights. Hear me and hear me well. Consumer law is about protection. It's not about rights. Because you as a man or woman cannot get your rights from the government. Because think about it. Consumer law is what, y'all? It's federal law. Federal law is what, allegedly? The government. The government, you did not come through the world through the portal of the government. So the government did not create you. So technically, they can't create no rules for you, which is why they also have you calling each other, why they have us calling each other citizens. Again, that's a video for another day. But all these things are connected, if you follow what I'm saying. So consumer law was created for consumers. So when you do consumer law, that's another reason why you go do consumer law, and then you're like, because I'm a man, I'm a woman, and then you don't want to act like consumer law got nothing to do with you. Well, if you use a consumer law, you have to identify as a consumer. If you do commercial law, you have to identify as a businessman, a businesswoman, or a merchant, or a corporation. Because now merchants are people and they are corporations. So you are either going to be a businessman, a businesswoman, a corporation, or a merchant. God's law, back to my point, is man and woman. Like he created man, woman, the dogs, the trees, or whatever. So if you're using God's law, 9 times out of 10, you're only going to be a man or a woman. Biblically, again, don't take what I'm saying out of context. You are not supposed to have any false gods or any false idols. And if you are going to obey God's law, then the only law that you abide by is the law that's in the Bible, or the law that's in your book of reference. Whatever, again, that's the Quran. I keep saying Quran because that's the only one I really know outside of the Bible was the Quran. If it's some other ones, y'all let me know, because I don't want to be on here ignorant. Oh, I got comments. Wait a minute. Negotiable seemed it was not a contract. There you go. Misrepresenting terms, left out loud, promise or no contract. Y'all got it. UCC can be used for consumer agreements. Just use CCC. Consumer law. I'm not even going there. Make it make sense for yourself, love. As long as you can do that, you're always going to be fine. I don't want to argue with the technicals. I said what I said. Consumer The UCC governs commercial transaction, and it breaks down certain things in the aspect that I was talking about. All right. So that's that. In the reference that in the context that I was talking about, that's I said what I said. All right. So then you got God's law, which is man or woman. So if you're using God's law, you are supposed to have dominion over the land. If you are using God's law, from what I read and from what I understand, the land can't be sold. If I read the Bible and I read God's law, we are the descendants of Abraham. We have the promised land. The land is ours. So for me, and I know that some of these things are not popular and that we're not in that space. However, just because it's not popular and just because people are not talking about it and just because we have decided to get away from it doesn't mean it's not true. So for me, my whole thing is, why the hell would I go sign a 40-year mortgage if God's laws say that the land can't be sold? So who the hell am I buying it from? Because if you don't own the land, why the hell am I buying? Why am I buying it from you? Now the idea is you technically aren't buying the land because nobody owns the land. So what you're buying is the houses, the house or the building that is attached to the land. So then one can say, then just find a piece of land and build your own house, or build your own building upon the free land. I'm just talking about what I'm talking about. So, but that's what it says. And there are supposed to be no other gods before me and all those different things. So if you stop believing in God's law to now abide by all of these laws, are you really operating under God's law? And here's the one thing I want to say about this. In God's law, there are conditions. And I was just talking to my mother about this, and I've been reading and studying it literally and just remembering it for the last 3 weeks. There are conditions in the Bible where it is God's law is conditioned. And there's some things you just get because you get, but there are some things that requires I call them if and then statements. In the law, they're called if and then statements. If you want certain things, then you have to do this. So I'll give you an example. If you seek, you will find. So yes, if you seek, you'll find. But then you got to pay attention to where you seek it. So if you're under God's law, should you be seeking all these master classes that's going against God's law? Should you be seeking commercial law that's going against God's law? So you have to decide. Again, the God's law say you can't be lukewarm. You can't be, you're either hot or you're cold. So you can't be all these things. You got to pick a side, y'all, and you got to stay there. You got to pick a side and you got to stay there. You can't be tossed to and fro. You can't be double-minded. You can't be unstable. You can't be, well, this didn't work, so I'm going to go do this. You can't be tossed to and fro. Your yay got to be your yay and your nay got to be your nay. Now, am I saying that you can't change your understanding because as the more you study these things, and even with myself, some things that I thought was true that I knew turned out not so much. Some of the things that I thought that was wrong actually turned out to be actually right. So as you study these things and as you seek, things will be revealed to you. And so you're understanding, you're learning every single day. So what you think is right today might not be. But again, are you really seeking or are you just regurgitating? Because that's a difference. I'm just talking about what I'm talking about. Are you really seeking or are you just bouncing from here to there, here to there? You just Instagram this and masterclass this and webinar this. Instead of saying, let me go seek for myself. Now, you got people that's going to plant the seed, but you got to go do the seeking. And where you doing the seeking, that matters. Because it depends on how you use it. And then, of course, we all know what constitutional law is. So is your claim going to be constitutional? Because if your claim is going to be constitutional, right, then you should be using things that have something to do with the Constitution. And when you do the Constitution, most of the time the Constitution identifies people as citizens, right? So then if you're using this, then 9 times out of 10, you're going to be identified as a citizen. And in some cases, is there something wrong with identifying as a citizen? No. So if you got to identify as a citizen and get the remedy or get things, and this is where the protection is coming from, that's fine. That's fine because, again, the Constitution did not give you rights. It gave you protection of your God-given natural rights. hear me and hear me well. The Constitution did not give you rights. It gave you protection for your God-given rights and your natural fundamental rights. The Constitution was protection. So if you have to use the Constitution for protection from those who are abusing their public power and policies, then absolutely, then you may have to identify as a citizen. It's fine. You're not going against God law, because at that point, you're protecting this. Does that make sense? And then you got common law, which common law really is more of equity. And equity is, most of the time, you're going to identify as a man or a woman. I haven't really seen too much outside of that I can speak on. So when you're doing common law, it's man or woman. And when you're doing contract law, then you're doing contract law. You enter into the contract. Now again, depending on the contract, I'm going to erase this. Depending on when you do a contract, depends on how you enter the contract, right? So now you got contract law. And I just saw where somebody said this. So you got contract law. Now the elements of contract law is going to be the same yesterday, tomorrow, so they probably change it. Contract law is also a part of equity. Contract law is also a part of the common law. But how you entered into this contract is going to make the difference on which one, because everything pretty much is contract. You can't really sue somebody if there isn't some form of contract. And contract does not always have to be written, guys. Contract can literally be implied. It can be oral. You get what I'm saying? So it doesn't always have to be reduced to writing, but there is some type of agreement. And then there are always the elements of a contract that have to be met. Elements must be met. But what's going to matter and determine is, did you enter the contract as a woman or a man? Did you enter the contract as a consumer? Or did you enter the contract as a merchant? Did you enter the contract as a business / corporation? So it's always typically going to go back to contract. But the laws that's going to govern you in your litigation and in your lawsuit is going to be, how did you enter into the contract? So a man and woman entering into a contract would be something like me and my girlfriend, me and my sister. We had an agreement. Hey, I'm gonna watch your baby for a week, and you're gonna pay me $100. That was a contract. She's a woman, I'm a woman, so that is a contract that we entered into as women. If there was a man and they say, bro, I'm a give me all your Jordan collection, and I'm gonna give you $1,000 in 2 weeks, and they enter into that contract as agreement. That contract is between two men, right? It's gonna be man and woman, and it's probably gonna come under equity in common law. Again, if you are a consumer and you insert, so remember, everybody that buys anything is considered a consumer. But there are two sides to consumer. I told you, personal, household, or business. So yes, you can be a consumer. So consumer is not just us as men or women. A business also is a consumer, right? So now, how did you enter into the contract as a consumer? As personal, merchant, or business. And so if you enter into it for personal, then it's either you can use equity, common law, contract law, of course, because those are always going to be there. And then you can use the consumer laws, if that also is going to help you. Merchant and business is always going to be merchant law in the UCC. Okay? So again, it's tight, but it's right. And sometimes it just is what it is, okay? So again, that is the context, and this is why you are going to have it. This is why most of you guys have issues with it. Go through your case, write your facts down, and then decide which one you're going to be. And then base your complaint and your lawsuit off of one. Do not go back and forth. especially when you're just starting this out. And I'm not saying at some point you cannot, but most of us are not skilled to do that. And so you got to crawl before you walk. And there's no reason to make this harder than what it has to be. So if your issue really is contract law, use contract law and leave the UCC out of it. Or use, unless for some reason it works for you. All right, I just paused out. Then you can do that, okay? So go through. So I wanted to show you guys that. Go through that, and then you'll find that you'll be able to, one, have a clear head, because now you have decided which way you're going to go. Now you can go and find cases and study how you can use those, whatever law you decide, to your benefit based on the facts that happen, based on your injury and your damages. Then based off of that, then you can decide the available remedies, because all of these laws, and depending on how you do it, have different remedies, right? They're all not, all remedies are not equal between all of them. So, because if you do equity, guess what? Equity isn't about money. Equity is rescinding contracts. Equity is about get that shit off my credit report. Equity is about give me my interest rate, give me my dividends. Equity is about fraud. You get what I'm saying? So it really just depends. The consumer law is going to be when somebody violated your protection under those consumer laws. But don't create this big pile of things that don't exist. Write down the facts, decide what law you're going to use, and litigate your claim and draft your complaint up based off of that. Give the court something to work with, and don't have them jumble all around, because they're not going to go through it and it's not going to work, okay? So I hope this video helps. I hope it makes sense. We're going to dive deeper into this. I think I got through a lot of it today because I stayed on longer than I actually wanted to, but it's all good. The second part that I'm going to do, and I probably will come back on Tuesday, because I'm not coming back tomorrow, Saturday. Sunday is, I'm not going to come, and that's Christmas Eve, and then Monday is Christmas. So Tuesday. Let's meet here on Tuesday for part 2. And what I'm going to actually show you is a response to a lawsuit where we actually use the UCC. And I follow up based off of a process that somebody already did, and I wanted to test out that whole UCC 3603. And so I'll actually show you how you're going to actually have trouble responding if you kind of don't follow this format. So again, I hope this video helped. Like, share, make sure you guys turn on your notifications. Subscribe to the website. I'm doing a class, but before I do the class, I want to make sure that all of my back and stuff is done, because I'm white clearly thin. I want to make sure that the cases is updated, the laws is updated, so that when I come and give you this class, it's effective. I don't want to do another class where we get the information, it makes sense, but it's not effective. So I feel like we got enough information. It's time to really do it so that it's effective. So behind the scenes, I am perfecting processes and doing different things to make sure that when I come and teach it to y'all, I'm not regurgitating and I'm not Googling shit. I'm telling you what I know, because y'all know I stand firm on, I'm not telling you what I Googled, I'm telling you what I know. And experience, as hard as it is sometimes, is our best teacher. So make sure that you guys are subscribing so that you can get the next date. I know I was supposed to do a class on December the 16th, and I told you guys I was going to do it, but I decided to go a different direction, and it just didn't work out the way that I thought it was, and that's okay. So I have to figure out another date and get some things done on the back end. In the meantime, in between time, I'm not accepting any more clients for any litigations. I'm not drafting any more motions or anything like that. However, I am available for structure and strategy. So if you guys are thinking about suing somebody, if you want to do a lawsuit because you feel like your rights was infringed on and you don't know which way to go, if all of this is confusing and you need help working through this, if you book a consultation, I'll actually do a one-on-one with you, and we'll create an actual structure and strategy to kind of navigate you on how to do that. If you typed up a notice and a complaint and you're not sure if it looked right, something might be missing, you might need to add some little razzle-dazzle. You might need to know, how do you prove your claim? What type of exhibits should you add for evidence purposes? We do document review services. So you can book a consultation for document review, and I will go through the documents and I will tell you if I think it's trash Y'all know I will tell y'all if I think it's trash. I'll tell you like this shit is not gonna work. I'll tell you, okay, this is good, but maybe you need to tighten it up. And again, that is not legal advice because I'm not an attorney. I'm just telling you what, you know, my opinion. If you value my little old opinion, then book your consultations. You can do that. The link is on the website. I hope, know the article through negotiations. Exactly. All right, so I hope this video was helpful. As always, I got you guys covered. Keep going, y'all. Keep pushing, even when you don't feel like it. And it's your girl, Meet the One. Bye, y'all.